Hello, my name is Laura Richard, and I'll be evaluating the terms of use for Priceline.com's website. A website's terms of use is an electronic contract that establishes the rules governing the relationship between a site and its visitors. If disputes arise, a well-crafted terms of use can protect the website publisher and help resolve the problems in its favor. By definition, a contract is an agreement with specific terms between two or more persons or entities, in which there is a promise to do something in return for a valuable benefit known as a consideration. To be legally enforceable, all parties involved must agree to the terms of the agreement. For traditional offline contracts, the parties' signatures provide evidence of acceptance. However, with more business being conducted online, an alternative to signatures on hard copy contracts is needed. In response, state and federal lawmakers have passed acts such as the e-Sign and Uniform Electronic Transactions Act. The Uniform Electronic Transactions Act, referred to as UETA, was established to create uniformity among state laws governing the validity of electronic signatures and the enforceability of electronic contracts. 47 states have adopted some form of the UETA, but discrepancies exist between each state's versions. To address these discrepancies, Congress enacted the Federal e-Sign Act in 2000. The e-Sign Act states that regardless of any particular state law, no contract or signature can be declared invalid or denied enforceability simply on the basis that it is in electronic form. While electronic contracts and electronic signatures are recognized by federal and state governments, there is no standard definition for what constitutes an electronic signature. And many fundamental aspects of contract law are up to the courts to decide when disputes arise. There are two main types of electronic agreements. One is a click-through, also called a click-wrap agreement, and two, a browse-wrap agreement. A click-wrap agreement requires a person to click on an acceptance icon to indicate their assent of the terms, while a browse-wrap agreement is typically based on the use of the site as the indicator of acceptance. Studies have shown that most people online do not take the time to read a website's terms of use or privacy policy before accepting the terms. However, having actually read the terms is not a main determinant for the courts to enforce an electronic contract. Rather, courts look at whether the user had an opportunity to read the terms. The key to enforceability, therefore, is user notification and clear user assent. Courts tend to favor click-wrap agreements since they require affirmative confirmation by the user, such as checking a box. Browse-wrap agreements are viewed more skeptically, but the main determinant is how prominently the terms of use are displayed on the site. In the 2005 case of Hubert v. Dell Corp., an Illinois State Appellate Court took note of how prominently Dell had warned the user that Dell's terms and conditions would apply and reversed the trial court's refusal to compel arbitration. To summarize, the appeals court held that the blue hyperlink entitled Terms of Conditions of Sale appeared on numerous web pages during the order process. And although there was no conspicuous requirement, the hyperlink's contrasting blue type makes it conspicuous, and an experienced computer user would know to click on the hyperlink for more information. Contrast the Dell case to the 2009 Heinz v. Overstock.com case, where the court ruled that Overstock.com had not provided sufficient notice of the site's terms and conditions, and as a result, the plaintiff had neither actual nor constructive notice of the terms and conditions. Unlike other cases where the courts upheld browse-wrap agreements, the judge concluded, in the Overstock case, that the notice entering the site will constitute your acceptance of these terms and conditions was only available within the terms and conditions. Since Heinz was never prompted to review the terms and conditions, and the only reference to the agreement was a hyperlink in small type at the bottom of the page, Overstock had not provided sufficient notice. There was no meeting of the minds necessary to form a contract. Priceline.com uses a browse-wrap agreement, and in my opinion, it does not provide prominent notice to users. The notice that reads, "Before submitting an account registration form and/or using any of these services, please read all of this agreement carefully. By accessing any areas of this site, users agree to be legally bound without limitation, qualification, or change to abide by these terms and conditions, which will constitute our agreement. If at any time you do not agree with any part of this agreement, you must discontinue use of this site." This statement is contained only within the terms of use. The terms of use appears as a hyperlink in small font on the bottom of the page. When visitors create an account, the registration link is located at the top of the page. And unless the user scrolls down below the fold, they'll never see the terms of use link. Furthermore, during the account creation process, the user is never prompted to review the site's terms of use. Priceline's inconspicuous browser wrap agreement does not show meaningful assent on the part of the user. There are additional problems with Priceline's terms of use beyond notification and user assent. Priceline's agreement could be summed up in 7 simple words. Use this site at your own risk. The terms of use are extremely one-sided and leave the user with no choice or power to negotiate. This type of contract is referred to as an adhesion contract. There is nothing unenforceable or wrong with an adhesion contract. The problem arises when a contract is so one-sided that it is overly unfair to the weaker party or strongly favors the party who has the superior bargaining power. In this instance, the courts will deem that the adhesion contract is unconscionable, and it may refuse to enforce the agreement against the weaker party. In such a case, a court can find that there is no meeting of the minds of the parties to the contract and that the weaker party has not accepted the terms of the contract. Following are examples of the most egregious clauses. They include Section D, Accounts Security Passwords. Priceline.com is not liable for any loss that you may incur as a result of someone else using your account, either with or without your knowledge. Section E, Privacy Policy. Priceline.com makes no representation or warranty with regards to the sufficiency of the security measures used for data handling and storage. Priceline.com will not be responsible for any actual or consequential damages that result from a lapse in compliance with the privacy policy because of a security breach or technical malfunction. Section F, Disclaimers of Warranties. Basically, Priceline.com makes no warranty or representation that the site will operate properly or that its contents is accurate. It states that no warranty or guarantee is made regarding the acceptance of any request, that a user will receive the lowest available price for goods and/or services available through this site, regarding the availability of products and/or services through this site, or where applicable at any participating retailer or retailer location, or regarding the results that may be obtained from the use of this site. Section H, General Limitations of Liability. Basically, this section states that neither Priceline.com or the covered parties are liable for anything, even when their site was at fault or caused harm or loss. Section L, Response to Requests. While Priceline.com will use its good faith efforts to respond to requests within the time periods indicated on this site, no guarantee is made that the status of your request will be made available to you within the stated processing time. Section O, Pricing Errors. We endeavor to publish and maintain accurate prices and information for the services we offer, including but not limited to our Name Your Own Price services. In the event, however, that a service is listed or provided to us at an incorrect price or with incorrect information due to typographical error or other error in pricing or service information received from our travel services providers, Priceline and/or the travel service provider retains the right to refuse or cancel any request placed for such service. Priceline and/or the travel service providers shall have the right to refuse or cancel any such requests whether or not the order has been confirmed and/or your credit card charged. I wanted to call out one section in particular relating to modification and termination. Section N states that Priceline.com reserves the right in its sole discretion to modify, suspend, or terminate this site and/or any portion thereof, including any service or product available through the site and/or your profile, account password, or use of the site, or any portion thereof at any time for any reason with or without notice to you. This type of language is typical in terms of use, but it does not hold up in court. In the case of Harris v. Blockbuster, the judge found that there is nothing in the terms and condition that prevents Blockbuster from unilaterally changing any part of the contract other than providing that such changes will not take effect until posted on the website. As a result, the court deems the arbitration clause illusory. When a person or company promising performance makes the choice of performance or non-performance at their discretion, it is considered illusory, and it does not form a contract. While several aspects of Priceline's terms of use trouble me, there are provisions that are valuable and should be retained. These include jurisdiction. The terms of use set forth that the laws of Connecticut shall govern the performance of the agreement, and users must consent and submit to the exclusive jurisdiction of the state and federal courts located in Fairfield County, Connecticut. Also, in an age of terrorism, where airplanes and other forms of public transportation allow global travel and acts of terrorism are possible, it's important that travelers purchasing tickets be identified, and also that they be aware of travel risks to foreign countries. Priceline's terms of use do a good job addressing the issues of identity and offer severe repercussions for fraudulent or illegal use of the site. The Travel Services section also provides valuable information for travelers to help them stay safe. Copyright and trademarks. The provisions regarding copyright and trademark notices are thorough and necessary. Ownership of content. I also agree with the need to define ownership of any comments or posts on the site which Priceline.com can use or remove at their discretion. Minors. Lastly, the terms incorporate the privacy and address the issues of minors and prohibits anyone under the age of 18 from using the site. In addition to keeping the above cited provisions, I recommend Priceline.com modify its terms of use as follows. Adopt a click wrap agreement and require users of the service to agree to the terms at the time of account creation by checking a box. Remove the clause that allows Priceline.com to change the terms of use at any time without notice or consent by the user. Instead, adopt the practice of emailing and providing RSS feeds to users whenever the terms of use are changed. Provide reasonable assurance of security, particularly since users are storing their credit card information, and allow them the opportunity to delete their card information from the site. Add a clause of severability. In the event any provision of the agreement becomes unenforceable for any reason whatever, it will be treated as void, and the remaining provision and terms shall remain in full force and effect. Disclaim warranties in compliance with the Uniform Commercial Code, UCC. The UCC allows sellers to disclaim both express and implied warranties within reasonable limits, considering the circumstances. Disclaimers that are too broad will not be enforced, and neither will disclaimers that take away all users' rights. The user must have some meaningful remedy if the service he or she receives are defective. By making these revisions, Priceline.com will have a terms of use that is legal and enforceable.